Mr. Speaker, I declare that I'm a medical doctor and specialist in medical oncology in private practice. In supporting this bill, I will speak on 3 points: vulnerable victims, expert witnesses, as well as vulnerable persons of unsound mind. Mr. Speaker, as part of the broader discussion of the criminal justice system, I'd like to make some points on the Evidence Amendment Bill as well. I concur with many of my colleagues who have spoken earlier. It is high time that we provide for appropriate restrictions on the kinds of questions and evidence that can be asked in criminal proceedings that involve sexual offenses or child abuse offenses. We recognize that our judiciary is impartial and can decide what is an inappropriate question to a witness, but by then, the question may have already been asked. Our legal profession is held in high regard, with only a small minority of practitioners censured for inappropriate questioning. But by then, the question may have been asked. And so there is still a role for safeguards, because by the time an inappropriate question has been asked to a sex offense victim or a child abuse victim, it is too late to undo the psychological trauma caused to the person being cross-examined. And so we must avoid the risk that victims will be deterred and afraid from coming forward to give evidence because of the fear of being subjected to inappropriate questioning during cross-examination. Mr. Speaker, indeed, it is even conceivable that a malicious, calculating defendant may seek to mislead his counsel into asking inappropriate questions on sexual history so as to deter the other victims from coming forward. Victims of sexual abuse and child abuse have suffered terribly already. We must avoid a situation where unnecessary additional suffering is visited upon the victims. Mr. Speaker, my second point is on regulating expert evidence through subsidiary legislation. And the proposed amendments will allow subsidiary legislation on the use of expert evidence, including the obligations of evidence and the use of concurrent expert evidence, which has been colloquially described in some jurisdictions as hot tubbing, or the use of what they call joint expert reports. And these amendments, and in particular the clarification of expert witnesses' duty to the court, are very much welcome, because as our society and justice system mature, expert evidence is increasingly sought to be introduced in legal proceedings, including criminal hearings. For example, the use of medical evidence in criminal proceedings is becoming more commonplace, whether it is relating to the nature or cause of injuries, the mental state of the accused and its impact on the commission of an offense, or the possible explanations for or the significance of a substance that may be found in the blood or urine of an accused person. So the creation of rules to regulate the giving of expert evidence will ensure that such testimony is held to strict as well as consistent standards and taken in an effective manner that will advance the pursuit of truth. And indeed, the practice of hot tubbing has been adopted in civil proceedings in Singapore for some time. As it involves the concurrent giving of evidence in an inquisitorial manner, hot tubbing can reduce the time taken to take evidence from experts and also fosters a respectful environment where experts can put forward and have their opinions tested. In a recent case involving an application under the Mental Capacity Act for a declaration that a woman was unable to make decisions to her property and affairs because of a mental impairment, the Court of Appeal suggested in a postscript that ideally, medical expert evidence in such cases should be tested through hot tubbing, and there can be benefits to extending this procedure to criminal hearings. Mr. Speaker, it might be useful to share a medical perspective. Currently, when a patient presents with a complex medical condition, a case conference may be convened. Multiple experts from the same specialty may attend, or even multiple experts across multiple specialties. In oncology, we call these conferences tumor boards. Other medical specialties will have their own names for such conferences. Such conferences are routinely held at reputable specialist centers around the world: Singapore, the USA, UK, Australia, and so on. And it's important to note that such case conferences are not adversarial by design. Experts can ask questions or offer comments on other experts' views. Clinical information is presented and discussed concurrently by a panel of experts. So opinions can be tested or clarified with the aim of seeking understanding of the scenario faced and what the range of appropriate decisions would be. Sometimes the discussion generates a range of opinions, which the panel assesses to be within the bounds of what is appropriate. Now, Mr. Speaker, the case conference approach to medical expert decision-making in the context of clinical practice and patient care seems closer to the inquiry-based, inquisitorial approach proposed for hot tubbing as compared to the adversarial approach. To clarify, I'm not saying that medical expert case conferences are exactly the same as a hot tubbing model of expert evidence in court. But one might suggest that there are useful lessons which can be drawn. So this review of how the courts manage expert witnesses, especially medical expert witnesses, is to be welcomed. It can help the court arrive more swiftly at an understanding of evidence and what the key issues are, especially for medico-legal cases or where the medical evidence pertains to a criminal case. Medical experts would also be able to discuss the evidence and provide opinions in an environment which more closely reflects the actual clinical decision-making and opinion formulating in day-to-day, real-world, responsible expert practice. This would also provide educational value for counsel as well as patient advocates. But there are clarifications that we need to ask of the minister. Firstly, what sort of subsidiary legislation will be enacted to regulate expert evidence? Secondly, will there be consultation on the proposed regulations? Thirdly, in particular, each expert domain, whether engineers, computer security, medical professionals, each will have their own established professional practice for discussion of complex expert cases. So there should be consultation with the relevant professional bodies before the regulations are enacted.